Thank you, Leigh, and thank you, Pennsylvanians for Modern Courts, for allowing me to present today regarding landlord-tenant disputes. Just a little bit by way of introduction that I'll do. So I am a district judge. My district is in the city of Pittsburgh, Allegheny County. My jurisdiction's fully in the city of Pittsburgh, so we handle all matters that that occur in the city of Pittsburgh, including criminal procedures, traffic, landlord-tenant matters, civil, non-traffic citations, including truancy, as well as doing arraignments for anything that happens in Allegheny County that is a criminal offense. So we have a central arraignment court that operates 24/7, which myself and the other 45 magisterial district judges in Allegheny County also work at. So I to date, I did my landlord tenant data this morning for you to give you an accurate number. So since I've been on the bench, which has been a little bit over 2 years, I have presided over 950 landlord tenant cases in just over 2 years. So I'm busier in terms of landlord tenant cases. So I'm happy to do this presentation to try to make people aware of the process, the procedures, and just aiding both sides, landlords and tenants, as to what you should bring to court to better present your case. Where does a landlord-tenant dispute fit in? So if you take a look at the pyramid chart here, you'll see that these are all the judicial branches and levels within Pennsylvania, being the Supreme Courts being the highest, the intermediate appellate courts, which are Superior Court and Commonwealth Court, Common Pleas Court, Municipal Court, which we have in Philadelphia County and in Allegheny County, city of Pittsburgh. And then our magisterial district courts, which, as I said, there are 46 individual magisterial district courts in Allegheny County, one of which is mine. And there are 13 in the city of Pittsburgh. And this is where a landlord-tenant matter would be filed, is at a magisterial court where the rental property is located. It does not matter where the owner resides. It is the complaint must be filed where the property is physically located. So just a little brief overview of what some of the things that we handle in magisterial district courts, which I briefly touched on too. So civil action cases with $12,000 being the limit, excluding court cost. Landlord tenant matters, this is also capped at $12,000 excluding court cost. Summary offenses, which, as I already did mention, are non-traffic citations, which could be truancy, underage drinking, disorderly conduct, harassment, things of that nature that are not graded as a criminal charge. Violations of municipal ordinances. These are building code cases, which all of the magisterial district judges also handle in their municipalities. We do criminal preliminary hearings and arraignments in greater misdemeanor and felony charges. And as I already said too, there are 46 magisterial district courts within Allegheny County. Okay. Allegheny County Court of Common Pleas. We are the 5th Judicial District of Pennsylvania. And the Court of Common Pleas hears appeals from the minor courts and appeals not exclusively assigned to another court. Common Pleas will adjudicate matters involving children and families. Common Pleas Court holds civil and criminal jury trials. There are 43 Common Pleas judges in the 5th Judicial District. And Common Pleas Court will handle disputes and issues involving more than $12,000. So if a landlord-tenant matter, if the landlord is seeking judgment for over $12,000, it cannot be filed in any of our magisterial district courts. They must go to the Court of Common Pleas. That is also true for a civil proceeding. Court administration. So actually, this slide, we do have a new president judge. Our new president judge is Susan Avashevic de Lucente. She became the new president judge effective late December of 2023, and that is a 5-year term for her. She is a former magisterial district judge, actually. She represented Churchill, Forest Hills, Swissvale, that the areas out, some suburbs in the East End. So she is a former magisterial district judge who was elected to the Court of Common Pleas in 2007. But here are the divisions within the Allegheny County Court of Common Pleas. Civil division. In the civil division, Judge Christine Ward is still the administrative judge of the civil division. They handle torts, contract disputes, malpractice, arbitration, landlord-tenant disputes greater than $12,000. So any civil actions regarding, monetary between two parties, that's done in the civil division. The criminal division, the administrative judge is Judge Joe Rangos. And in the criminal division, The criminal matters would be that the preliminary hearings that are held for court by magistrate district judges are elevated to the criminal division in common pleas. These would include felony charges, misdemeanors, as well as adult probation. Family division, the administrative judge Kim Eaton. Family division handles divorce proceedings, child support, juvenile, child court, and protection from abuse orders. Magisterial district judges handle emergency protection from abuse orders, but to get a temporary and a permanent protection from abuse order, you must go to the family division. In the last division within the Court of Common Pleas is Orphans Court. President Judge is Judge Lawrence O'Toole. And in the Orphans Court, matters handled are wills and estates, civil commitments, adoptions, and guardianships. Residential mortgage foreclosure program, Save Your Home. The diversion program requires that before the court can make a judgment, there must be a conciliation conference where the homeowner and the mortgage company can have a chance to work out an agreement. It is called a diversion program because the normal lawsuit process is diverted or turned away from its ordinary course for this conciliation conference to happen. Eligibility for the program. In order to be eligible for entry into the program, the borrower in question must meet the following criteria. A complaint for mortgage foreclosure must have been filed with the Allegheny County Department of Court Records, Civil Division, with the MG docket number. The property must be owner occupied. The property must be of 4 or fewer units. Commercial properties are not eligible for this program. After a complaint is filed, the homeowner can participate in the program. Is initiated by a phone call to the Allegheny County Department of Economic Development Save Your Home hotline. Numbers provided 1-866-298-8023. 20. Intermediate appellate courts. I briefly did touch on these, but there are 2 in Pennsylvania that are below the Supreme Court. The Superior Court hears civil and criminal appeals from Court of Common Pleas, including matters involving families and automatic right of appeal. Commonwealth Court hears original actions brought by and against the Commonwealth, appeals from decisions made by state agencies, and some appeals from the Court of Common Pleas. Commonwealth Court. General election 2022. Let's see. Count the undated mail ballots. Objections to nomination papers of state-level minor political party candidates and independent candidates of political bodies. President Judge Renee Cohen Jubileer. There's some facts about the court as well. There are 9 judges that sit on the Commonwealth Court. They're 10-year terms, and they are up for retention after that. Superior Court, a little bit larger of a court. There are 15 judges on the Superior Court, also elected statewide. And after their terms are initially 10 years, subsequent to that, they would be up for retention, which is a yes or no vote. Current president judge is Judge Jack Piniella. And the Superior Court, let's see here, we have Commonwealth versus Ruffin. This is a partial obstruction of vehicle registration plate is a violation of law, and police can't stop a vehicle. Suppression motion denied. And then Coleman versus Grand Healthcare 2022 found a nursing home arbitration agreement unconscionable. 1, individual was physically and mentally incompetent during signing. 2, document was not read in the entirety to her to ensure she understood, nor was Vincent's family consulted, nor was individual provided with a copy so someone else could read it to her. Requiring nursing home residents to pay 50% of an arbitrator's fee was so unreasonable that it was per se against public policy and inherently unenforceable. So there's some recent rulings out of the Superior Court. In the Supreme Court, which is the highest court that we have here in Pennsylvania, the president judge is Justice Deborah Todd. Same thing here. These are 10-year terms elected statewide, followed by retention after that. And then we have a couple recent opinions here. Malenko versus Commonwealth 2022 upheld constitutionality of mail-in voting, reversed the Commonwealth Court decision. And then additionally, Commonwealth versus Barr 2021, smell of marijuana alone is not probable cause for a search. Pennsylvania Supreme Court, ultimate authority on matters brought before the lower courts. Review is discretionary in many cases. Review is mandatory for limited categories of cases, interpretation of state constitution, cases involving the death penalty, etc. King's bench power, power of extraordinary jurisdiction, meaning they are the highest court in Pennsylvania. So they do have, the Supreme Court does have the right to decide, what appeal cases they want to hear, as I mentioned, unless it's a mandatory review. PA Supreme Court has supervisory activities. So yeah, the Pennsylvania Supreme Court, they oversee the Administrative Office of Pennsylvania Courts, which is also known as AOPC, which is where the magisterial courts are housed. And we deal with the AOPC quite a bit. They handle all of our forms. They do our continuing education, which all judges must attend for 32 hours per year. That's the continuing education for all judges. They handle the budget of the entire court system. They also oversee the Judicial Conduct Board and special committees on the Supreme Court. They regulate practice of law, including attorneys, admissions, and discipline. So that all falls under the PA Supreme Court's supervisory activities. Landlord and tenants' rights and responsibilities. Renting a house or apartment is one of the most significant decisions you will make. Discrimination is prohibited. So, so federal and Pennsylvania law tells us that all individuals have the rights against discrimination when they are searching for housing and when they become tenants. Discrimination on the basis of race, color, age, religion, national origin, sex, gender identity, sexual orientation, disability, or familial status. Instances of discrimination do not require the tenant to go to court. Instead, if a tenant feels that they have been discriminated against, they may file a complaint with the Department of Housing and Urban Development, which is also known as HUD. Their phone number is available. Pennsylvania's Human Relations Commission, phone number is also available. Your individual county's Department on Human Rights, or the PA Attorney General's Civil Rights Enforcement section, which their phone number and website and email are listed. So those, if you feel you've been discriminated against based on any of these categories, those are the avenues you have to try to report this discrimination. So some examples of discrimination. The landlord says that the rent is higher than advertised after meeting the potential tenant in person or falsely denying that a unit is available for rent. The landlord does not allow full use of all home facilities or requires you to live in a certain part of the building. An advertisement states that a property is only available to people without children. Refusing to permit a person with disabilities to make reasonable modifications to the unit. Retaliating against you for opposing housing discrimination or for filing a complaint about discrimination. What are a tenant's rights? The implied warranty of habitability. So I see this quite a bit that is brought up in court. We'll be having a hearing and a tenant will come in and say that there are issues with the unit that they have sometimes they don't notify the landlord about them until the hearing, or they will have brought proof with them that they did notify the landlord of issues with the unit and the landlord has refused to fix them. But the implied warranty of habitability basically states that every tenant, it's implied, so it does not have to be written anywhere. Every tenant has the right to a habitable and livable unit without, deficiencies and issues with it. So the implied covenant of quiet enjoyment, right to use and enjoy the rental unit without reasonable interference by the landlord, right to exclusive possession of the residence, expectation of privacy, and unlimited access to the property. Landlord can inspect property with notice and can enter the property in emergency. So yes, that is true. Usually it's a 24-hour notice is required by the landlord if they have to enter the property for a reason. I'll hear sometimes that a landlord will have to go in to do something maybe with like a water meter, but usually, there's enough notice that can be given there unless it's an emergency. If your pipes are freezing and bursting, there's a potential gas leak. Obviously, that's an emergency, so your landlord can't enter to make sure that these things don't harm you or the property or any other tenant. So that would constitute an emergency. But generally, there needs to be a notice given by the landlord and for what reason they need to come into your unit. What are a tenant's responsibilities? A tenant's main responsibility is to pay the rent and pay it on time. They must also obey the terms of the lease. If the lease states that the tenant must pay utilities, the tenant must get bills from the landlord. Make sure to get a signed copy of the lease to monitor the rules and terms so you can obey them. The tenant must communicate with the landlord about repair issues as soon as they occur. It is best to do this in writing and to keep copies of this notice. In today's digital, technology world, we're seeing less and less like actual writing, like a letter or, or like taping something on someone's door. But I mean, I always say, as long as it's in some kind of written medium, if you normally communicate with your landlord via text message, that's fine as notice to your landlord that, hey, my stove's not working, my fridge is broke, my furnace isn't working. If that is your normal means of communication, that's fine. But it's in writing, and obviously you have a record of it, that it was sent on such and such a date and time. So if someone denies getting it, you certainly can just pull that up via your text. A lot of tenants now too, a lot of the landlords are larger companies, and a lot of them have, digital portals that you can put service and maintenance requests through. So once again, that is a written form that you could prove that you submitted written maintenance request. Same thing, email, if that's your like preferred, communication, but it's best to get it in writing regarding any maintenance issues or things that are not working. So let's see. Okay. The tenant should return the property to the way it was when they moved in, minus reasonable wear and tear, and also removing all of your personal belongings that were not in the unit before you rented it. If you paint the walls and they were white when you moved in, you may have to paint them back to white. This is always an issue that a lot of landlords, will allow you to do some painting if you've been there a number of years, but it's always best to ask the landlord before you just take this upon yourself, because usually it's best to try to go with neutral colors. Most landlords probably are not going to want like, a vibrant yellow wall, or so it's, if you're going to do that, I would strongly advise you to have a discussion with your landlord before you do any painting, or say, hey, can I freshen up these walls? Sometimes landlords will say, yeah, you know what, I'll buy you the paint if you want to paint it, so a communication is key with a lot of things, but definitely painting should be one of them that you should talk to your landlord before you would just do it. What are landlord's rights? A landlord can set rules about how the property and common areas can be used. Landlords are entitled to have keys to the property. If tenant changes the locks, you must give the landlord a copy of that key. Landlords have the right to evict the tenant using the judicial system. If a tenant does not pay rent or does not pay on time consistently, or if a tenant breaks or breaches agreements in the lease, some breaches can be repaired. Landlords must pursue evictions through the court system, which would be the first level would be at a magisterial district court. Landlords may require security deposits. Landlords are not responsible for a tenant's personal belongings. So, I mean, if it's best practice for tenants, you need to have renter's insurance, because I've had a few cases where there have been damages to the property, like as I mentioned before, pipes bursting, and obviously you have water everywhere. The landlord is not responsible if the water that, if pipes burst and you have some flooding in your unit, and it damages your couch, it damages a TV, anything like that. The landlord is not responsible to give you anything for these, and the landlord's homeowner's insurance, or property insurance, I should say, will not cover your personal belongings. It will simply cover their damages and their property repair. So it's important that you have renter's insurance to cover your personal property. What are landlords' responsibilities? The main duty is to maintain the property in good condition, keeping it fit and habitable, safe, sanitary, and accessible as determined by housing codes, repairs completed in a reasonable time. And that's worth mentioning too, because, reasonable time obviously is what one might consider to be a reasonable time. So it depends what kind of a repair it is. If your furnace breaks and it's January, reasonable time is much quicker than if, I mean, if there's just minor things that are wrong that are not, inhabiting you at all, but it's something that needs done, a loose floorboard, there's, a door on my vanity's broke. You can Landlords have a little more time to get to those items because they're not vital to your habitability. They might be an issue, but they're not something that, needs to be done like in 5 minutes. It's not that kind of a repair. So reasonable time, just what a reasonable person would expect, depending on what needs fixed. Not required to pay for damage, not required to pay for repair damage caused by the tenant. Multiple unit buildings, the landlord is responsible for maintaining common areas, and to meet safety and cleanliness standards, the landlord must provide drinkable water in the kitchen and bathroom, functioning bathroom with toilet and shower or tub, safe and functioning electrical system, no broken locks on doors or windows, accessible and working fire escape, hot water, heat during cold months. No cold air is required unless written in lease. So central air is not required unless it's in the lease. So you will have window units that you will see in some units, but obviously check that for your lease. And if you're looking at a property, you certainly are fair game to ask the landlord, does this unit have central air? And regarding window ACs, that would be between pretty much the tenant and landlord as to who would provide those or who would buy them. So that's between the parties with that, given the window units. Working sewage system, working smoke alarms, no leaking roof or broken windows. More additional landlord responsibilities. A landlord must inform a tenant of lead paint, lead pipes in the property before a tenant signs a lease. Landlord can be sued for triple the amount of damages. If the tenant pays the utility separately from the rent, the landlord must install separate meters. If they cannot be if the meters cannot be separated, the landlord must pay the utility bill and add it to the rent. If a tenant tells the landlord that the smoke alarm is broken, the landlord has 72 hours to replace that, as that is a safety issue. A landlord cannot do the following to a tenant: take or sell a tenant's property if they do not pay rent, shut off utilities or lock a tenant out of the property if they do not pay rent, also known as self-help evictions, harass a tenant, what a reasonable person believes. So it's not, I've had a few of these type of cases too. So it's not harassing a tenant if the landlord, simply texts or calls or, say, "Hey, hi, Miss Smith, it's now, April 6th. You haven't paid the rent yet. When can I expect that?" That's not harassing. That's just asking you when you're going to pay your rent. Now, if they text you 20 times in a matter of an hour about it, then that's probably not reasonable. But you have to just play that on a case by case kind of basis. But it's not harassing if the landlord is asking you when you're going to pay the rent, just, generally. Enter the property or allow others to enter the property without giving notice, except in an emergency, as I already mentioned. A landlord does not have to give notice if they must enter the property to do something on an emergency basis. Landlord cannot require a deposit for an assistance animal medical prescription. So if you have a service animal, the landlord cannot require you to pay a pet fee or deposit for a service animal. Landlord cannot cancel an existing lease of the tenants if the building is sold to a new landlord. So if property are sold, and I've had some of these cases too over my time, and if a tenant is into a current lease that say it runs until September of 2024, the property is sold today, so the new owner must adhere to the rent and the term of that existing lease. Now, if you're on a month-to-month lease or an expired lease, upon a new owner taking possession of the property, depending on what the notice to quit, or usually a 30 or 45 day is probably what would be in there. That you can be told by the new owner that they're only giving you a 30-day notice and you must vacate because your lease is month to month at this point. So that would be a reason you'd either have to vacate or they can take you to court for possession. Landlord must get court order to take possession of the property. That's what I just said regarding possession. So there must be a court order from our court or appeals court if it goes that far, but that's the only way to legally get possession is through court. Lease agreement, the most important document in landlord tenants relationship. So obviously it's something that you definitely want to read carefully before you sign it. What is a lease? A lease is an agreement between a landlord and tenant that a tenant can occupy and use a property for a certain amount of time in exchange for rent. Be sure to fully understand and agree with its terms before signing. Leases can be oral or written. An oral agreement is technically month to month. If the agreement is for more than 4 years, it must be in writing. The lease must be written in plain language, no fine print. Once signed, terms cannot be changed unless both parties agree. This is always bring your leases to court. Sometimes people don't, and that's a major issue because if myself or another judge wants clarification or has questions about things that the landlord is saying and the tenant is saying, we need to see the lease. So I mean, it's you would think that that would be something that, oh yeah, I definitely should bring my lease to court. You'd be surprised, some people don't. So that's, I have, when things are said and nobody provides me with a lease, you just have to believe who you think's more credible. But the lease is the Bible regarding a landlord tenant agreement. So that needs to come to court. That is a vital document to bring to court. What can a lease contain? The lease term. What dates is the tenant allowed to live there? When is the move in? When's the move out? Repairs. Who should make the repairs? Smoke alarms. Who is responsible to check the smoke alarms? Visitors. Can others stay for an extended amount of time? Limited locations on property. Entering. Must the landlord provide the tenant provide the tenant notice before entering the property? When, how, and why? Utilities. Who pays for which utilities? Is there a late charge? Who's responsible for snow, leaves, trash? Renewal or termination. Can the lease renew or does it just terminate after the initial term? If it's month to month, it will automatically renew unless the tenant or landlord give at least 15-day notice before current term expires. So all these notices will be in the lease regarding if after your initial term it goes month to month, who has to give, how many days notice must be given if a tenant wants to vacate, if a landlord wants to terminate the lease, how much notice needs to be given. So these are important things that would be contained in the lease regarding your terms and conditions. Beware of the fine print security deposit. During the first year of a lease, the security deposit cannot exceed 2 months' rent, which is called a double security deposit. During the second year of the lease, cannot exceed 1 month's rent. In the third year of a lease, any security deposit over $100 must be placed in an interest-bearing bank account. When move out, tenant must provide the landlord a forwarding address and return unit to condition in which it was found in order to get your money returned to you. The landlord has 30 days to return it. That's from the date you move out. That's 30 days. If any money is deducted, the landlord must provide written list of deductions for actual damages. If itemized lists of monies are not returned to tenant within 30 days, the tenant can legally sue the landlord as a civil matter, not a landlord-tenant complaint, because that's not the current situation. But a tenant could file a civil complaint where in the court where the property was located for double security deposit if it was not returned within 30 days. Now, one thing worth mentioning here is if a landlord files a landlord-tenant complaint against the tenant and the landlord ends up winning the complaint and there is, back rent owed, the landlord does not have to provide you with any of this because you owed them. If you owed them in excess of what your security deposit was, that is just forfeited as back rent payment. So that's, worth noting. So if you have a judgment against you for say $2,000, your security deposit is only $1,000. Your landlord is not required to do any of this. They don't have to give you a letter. They don't have to tell you why they're keeping your $1,000. It was because you got a judgment against you for $2,000. So they are keeping your security deposit. Beware of the fine print. Important waiver of notice to quit clause. If a tenant signs a lease that has this clause, the landlord does not have to give the tenant notice of eviction. Instead, the landlord can take direct legal action without telling the tenant. So a notice to quit, this term, the day term of it, I've seen anything. I've seen 3 days, I've seen 40. I mean, but whatever that is has to be specified in the lease. If there's no waiver, if there's no notice to quit required, the landlord, as it says, can simply, if you owe them rent or if your lease terms up or they believe you've caused damage to the property, you have a dog, you're smoking in the unit, any of these kind of things that are prohibited in the lease, they do not have to give you a notice to quit if it's not specified in the lease. So that is worth noting before you sign the lease. Are you waiving your notice to quit? So that's, and if there is a notice to quit, Leah, is there a notice? There's notice to quit slides. on here?
I think there's one or two mentions of
Okay,
it.
cool. Okay, I'll just wait then. Okay. Okay. The lease. If there's not, I'll talk about notice to quit but there's probably a slide on it though. But so the lease lead-based paint disclosure, there has to be the lead-based paint disclosure within the lease. Here's some rules and regulations on what can happen if they don't. This applies to any housing constructed prior to 1978, which a lot of rental units, unless they're newer construction, townhomes, condos, etc. A lot of rental properties were built before 1978. So this is a standard document through HUD that would need to be, given to tenants within the lease. Disagreements between the landlord and tenant. Communications and notice are very important. Yes, I say this all the time. Communication is key. A lot of things could be handled out of court, or you would have never had to go to court if there was just communication between the landlord and tenant, because parties will come in and they'll be like, oh, I would have taken care of that if you just talked to me. And I'm like, that's why I say communication is key. So it's good to have a good open relationship and communication with your landlord, and same thing with your tenant. Resolving issues outside of court. When any problem arises, the tenant should send a written notice to the landlord. If the landlord does not respond or does nothing, the tenant should send a second notice. Repairs. Take pictures of damage. Call 311 to file a complaint with the Department of Permits, Licensing, and Inspection. A health and housing code inspector will be sent. 311, this is for City of Pittsburgh residents with our City of Pittsburgh Permits, Licensing, and Inspection. They handle building code violations. And if you have issues inside your home that are relating to health, you could contact the Allegheny County Health Department for inside matters. They would handle that. Repair and deduct. Tenant makes repairs and deducts costs from future rent. Cannot exceed the monthly rent amounts. Keep receipts and estimates to inform the landlord of this action. Can a neutral third party assist in resolution? Before starting a landlord-tenant case, you should decide if court is the best way to solve the problem. You can solve many problems outside of court using things like mediation. We have Just Mediation Pittsburgh here, which I have flyers at my office, and I do recommend them for people if they feel they want to try that process. It's a free and confidential voluntary process. Here's their email. I'm sorry, that's their website. Or you can also contact Good Shepherd to learn more or find a mentor for your potential landlord and tenant issues. Early termination. Tenant has no right to terminate lease early. Tenant still has the responsibility to pay rent. The landlord is not obligated to locate a new tenant. If we get to this point, this is eviction, which would occur after an initial landlord-tenant hearing. What is an eviction? A landlord can decide to evict a tenant for the following reasons. The term of the lease has ended. The tenant has violated conditions in the lease. The tenant has failed to pay rent, or illegal activity by the tenant. Notice must be provided before any eviction process can begin, as I mentioned. So this is the notice to quit provision. So the notice must include the following information: name and address of the tenant's rental unit, the date the notice was served, the reason for the notice, the total amount due, including any late fees, where the payment should be made, and to whom the rent should be paid. If reason is failure to pay rent, the tenant has 10 days to pay or leave voluntarily. If reason is other than breach of lease, the tenant has 15 days to leave voluntarily. An ultimatum that the landlord may bring forth an eviction lawsuit. So this is where the notice of quit's important. So it's for some of these items that we've mentioned through here. So that's why it's important to initially look at your lease. And is there a notice to quit period? A term of days that this must be posted and given to you before a landlord-tenant hearing could be had. So that's why it's important to look at this in your lease. How is notice provided? Notice can be provided by personal delivery or posting the notice on a tenant's door. If a failure to pay rent, notice must be at least 10 days before any lawsuit can be filed. That's if the notice to quit is not waived. If a breach or term expiration, For at-will tenants and tenants who have lived in the rental unit for less than 1 year, landlords must provide 15 days written notice. For tenants who have lived in the unit for 1 year or more, landlords must provide 30 days written notice. Once again, that's if this is not waived in your lease. Notice continued. Waiver of the notice to quit. In lease that you signed, and landlord does not have to provide any notice. Some judges, not all, still want to make sure notice is given, but still no eviction without a court order, no self-help evictions. A self-help eviction when a landlord uses illegal means to evict a tenant. This can include turning off the utilities, changing locks, removing a tenant's belongings. Going to court. If a landlord wants to evict a tenant, the landlord must sue the tenant, take the tenant to court, and get a court entry of judgment and order of possession allowing the tenant to be evicted. How does a civil suit work? So we have two litigants in a landlord-tenant civil case, which the plaintiff would be the landlord and the defendant is the tenant. Determines whether defendant is liable for injury or harm done to the plaintiff, which in a landlord-tenant matter would be either property damage or failure to pay rent. The plaintiff must have a preponderance of evidence, meaning that the judge must believe the plaintiff's case 50.1% in order to rule in their favor. No right to an attorney. So neither party has to be attorney. Our magisterial district courts are, a lot of our litigants are pro se, meaning they represent themselves. We do have attorneys that will come in, to represent a party for a landlord tenant, a civil matter. But I mean, it's not, many litigants do represent themselves in landlord tenant and or regular civil suits. Who is involved in landlord tenant court matters? Judges, the rulings are binding, but they may be appealed. Court staff can direct the people where to go and enforce court etiquette rules. Lawyers provide access to the judicial system. Pro se parties represent themselves without a lawyer, may be able to request to record the proceedings. Security can remove unruly individuals from the courtroom. The courtroom is a public area. However, and all people are allowed to observe judicial proceedings. All parties should treat each other with respect and with courtesy. Where is a lawsuit filed? Landlord may sue the tenant either in the local magisterial district court where the rental unit is located, or in the Court of Common Pleas of the county where the rental unit is located if the matter involves more than $12,000. First step, complaint. Landlord and or tenant files a complaint with the magisterial district court where the property is located. There are fees involved with the district court cases. There are online forms that are available. The court may have advocates, interviewers to assist in completing the necessary forms, but this is not legal advice. We are not allowed to provide legal advice. I am not, nor is my staff. We have neighborhood legal services phone number that are pinned on all of our waiting rooms. That they will provide litigants with free legal advice. There's also the lawyer referral service, which can also provide attorneys who could be hired and or help on your behalf. Both court staff and judges are not permitted to give anybody any legal advice. Every complaint must include your name and address and amount of which you are suing and a short statement explaining why you are suing. Every county has different rules, so it's important to check your local court rules and the websites. Service of complaint and response. The complaint may be served by a court officer and or registered mail and or posted on the rental unit. The complaint explains that the defendant should respond to it. The court provides a date for a hearing, generally 7 to 10 days after service. By law, we have to have a landlord-tenant hearing 7 to 15 days after the complaint is filed. A defendant can file a counterclaim up to 5 days before the hearing. This could be because the tenant wants to sue the landlord at the same hearing for any expenses such as back rent repairs. What happens next after the complaint is filed? The plaintiff must then serve the complaint on the defendant. If the plaintiff does not serve the defendant or the service is defective, then the case will be dismissed. The court will set a hearing date. If the defendant does not show up, the court may enter a judgment against the absent party. If the plaintiff does not show up, the court may dismiss the case. Defendant can request a continuance to move the trial date back. The court may grant such continuances if the judge so requires. This request should be made in writing, in a written document or motion, and filed at least 10 days before the hearing date. Defendant should file a reasonable answer to the complaint and file a counterclaim. What a landlord should bring to support their case. As I mentioned before, a written lease. This is vital if you're coming to court for a landlord-tenant matter. You need to have the lease. Housing inspection license if operating a multi-unit building. A copy of the notice to quit unless the lease waives the notice. Unpaid utility bills if the lease requires the tenant to pay them. Photographs of any alleged damage. Proof of payment, invoice, and/or estimates. Communications between parties about damages. When in doubt, bring everything you have. It never hurts to bring more. But if a judge is asking you to see, let me see pictures of the damage. Let me see a repair bill for the carpet you're claiming that you had to get fixed because, there's burn holes in it. You need to have these things if the judge asks for them and if you're claiming them. Same thing with, you're saying, there's $1,000 in back sewage bills. Well, the judge is most likely going to want to see a sewage bill that says there's $1,000 that's owed on it. So if you're alleging that these things are damaged, owed on your complaint, you need to bring the supporting evidence because they're going to come up at the hearing from, between the cross-examination of the parties, or the judge may simply ask for them when the judge is looking at the complaint. So you need to have your materials ready if the judge and the other, also to show the other party as well. What a tenant should bring to support their case. To sue for repairs, habitability, running water, the written lease, pictures of the conditions of the property that a tenant is saying are not adequate or broken, damaged, etc. Notices to the landlord of the conditions. So if you've texted, emailed, put in the service request, you need to bring these showing the judge that these are the dates and times I've requested the landlord to fix these items, and to date, none of this has been fixed. To sue for a security deposit, you need the written lease again, documentation that the key was returned to the landlord and a forwarding address was provided to the landlord. Documents from the tenant to the landlord demanding the return of their security deposit. Once again, bring anything that you want the judge to see and that you want to say the landlord has not done. You need to bring pictures. You need to bring your text messages, your emails to support. You're saying notice was given to the landlord about your broken fridge. You need to bring something saying that you notified them and when you notified them of this. And then a month later, you still don't have a fridge. So you need to bring these items with you. What happens at a trial? Make sure you bring all your documents and have any witnesses ready. The judge will explain the procedures. Party filing the complaint presents their case first. So in this case, it's likely the landlord who brought the initial complaint to court. So they are the plaintiff and they will start the case. The opposing party and the judge are permitted to ask questions of the landlord after they present their case or during it. After all facts are presented, the judge has asked all their questions to either party. The judge may decide the matter at the conclusion of the hearing or send the decision out to both parties 3 days after the hearing, which is the entry of judgment. So regarding civil matters, a landlord-tenant case, the judges do not have to decide it at the conclusion of the hearing. And oftentimes I won't, because I have documents that I want to look at that I've made copies of and that I've collected from the plaintiff and the defendant. So I need time to review these documents. Therefore, I'm not going to make a decision immediately because I want to review them and I want to, make the best decision I can with the information I have. In a regular civil matter, a judge also does not have to announce the conclusion at the end of the hearing, but we have 5 days in a monetary civil matter. We have 3 in a landlord-tenant landlord-tenant complaint to make our decision and send it out to both parties by mail. Order of possession. If a judgment is entered in favor of the landlord still cannot evict the tenant by themselves. The landlord must wait 10 days after the entry of judgment and then ask the court to issue an order of possession. Court will serve the order of possession by mail at the last known address, and the sheriff or constable will serve the tenant personally or by posting it conspicuously at the leased property. Typically on the door of the unit is where it usually should be posted. The order of possession requires tenant to vacate within 10 days after the date of the service. If tenant remains in the unit on the 11th day, the tenant can be forcibly evicted by the sheriff or constable. If the tenant is forcefully evicted and leaves possessions behind, landlord must notify the tenant by first-class mail the right to retrieve their property. The tenant has 10 days from the date of notice to retrieve property or ask landlord to store for up to 30 days. If the landlord stores possessions of the tenant is responsible for the cost. If the tenant doesn't retrieve the property, the landlord can dispose of it after 30 days. Also worth noting too that the okay, no, so we're gonna get to that now. Okay, nope, we're good, Leah. Obtaining a stay of eviction. If a judge has entered a judgment against the tenant, a tenant must file a notice of appeal within 10 days to pause an eviction. If a tenant is a victim of domestic violence, the tenant actually has 30 days to appeal and file, but you must file a domestic violence affidavit, so the courts would be aware that you are a victim of domestic violence, which is the only provision for this 30-day appeal period. If a tenant does this, the tenant must deposit with court either 3 months' rent or amount judge ordered tenant to pay, whichever is less. Will still have to deposit rent each month while appeal is pending. This goes into escrow with the Allegheny County Civil Division. They will get, if you were to file an appeal, the Civil Division will give a tenant a payment schedule or plan, basically, that if you do not adhere to it, your appeal would be terminated. If the tenant is low income, the tenant may qualify for a IFP, informal pauperous waiver. This waiver will allow the tenant to pay only 1/3 of the monthly rent into an escrow account, and pay the other 2/3 will be made within 20 days. That kind of relates to what I was saying about a potential payment schedule or plan, but that's all done at the civil division. But you must adhere to whatever that payment plan or schedule is, or your appeal will be terminated. Appealing a decision. If a landlord or tenant wants to appeal a decision, they must first file a complaint with the Court of Common Pleas. If an order of possession was issued, an appeal must be filed within 10 days. If money judgment is entered, an appeal must be filed within 30 days. Here's the information for the Allegheny County Help Desk Housing Court. That is all and then we have those are their hours of operation on the right there, as well as their phone number. That's the civil division, which handles any landlord tenant appeals from magisterial courts. Here are some websites. Overview of landlord-tenant laws in Pennsylvania, Pennsylvania Landlord-Tenant Law, Landlord Protection Agency, Pennsylvania Rental Laws Apartments.com, Pennsylvania Security Deposit Law, Landlord Protection Agency, Tenant Rights, PA Lawhelp.org, and Tenants Right Laws and Protections, Pennsylvania HUD. Definitely a lot of useful information on those websites regarding your rights as landlords and tenants. And then there's a plethora of other resources available from the Pennsylvania Courts website, Allegheny County Bar Foundation Pro Bono Center, Pennsylvanians for Modern Courts, Neighborhood Legal Services, which I mentioned before is an organization that we have their notice on my billboard or on my bulletin board outside of my office for anybody to use for legal advice. Know Your Rights Consumer Guide, educating Pennsylvanians on rights under the Landlord-Tenant Law and Act. Okay. Additional resources. The Pennsylvania Office of the Attorney General Consumer Guide to Landlord and Tenant Rights, Pennsylvania Courts, Allegheny County Bar Pro Bono. Oh, okay, and Pennsylvanians for Modern Courts as well.